first case set for argument this morning is State of Ohio versus DeVante Gibbs. It's case number 17CA011116. Both parties are represented by counsel, so we will be hearing arguments from both of you. You each have 15 minutes to present your argument. The appellant may reserve up to 5 minutes for rebuttal. I'll keep track of the time, so let me know up front if you're going to take rebuttal time, and I'll let you know. I don't believe there's children involved in this one, right?
Yeah. There is, Jeff.
There is, okay. I thought there might be. So I'm not sure you're aware of the rule, but we refer to victims and children by initials as opposed to full names since we are being recorded. That also being said, we ask that you stay at the podium and keep your voice up so we get a good recording. The public gets a good recording of the arguments. We've read the briefs and we're ready to proceed if you want.
Good morning, Your Honors. May it please the Court. My name is Attorney Ian Crawford. I, along with Attorney Michael Sopanik, represent the appellant in this case, DeVante Gibbs. This case takes us back to September of 2013. During this time, Mr. Gibbs was living with his girlfriend, Jennifer Ballard, as well as Ms. Ballard's 2-year-old daughter, who we refer to as AC. On September 18th of 2013, Ms. Ballard was a student at Lorain County Community College, attended school that day. Mr. Gibbs, who was recently unemployed, stayed home to watch AC. When Ms. Ballard arrived back home later that day, she noticed that her daughter was acting a little strange, seemed to be sick. Noticed there was a blister on her foot, had diarrhea. She went to the drugstore, got some medicine for her. The rest of the night was okay. Woke up the next morning, she seemed to be doing fine, so Ms. Ballard decided that she should go to school. A couple hours later, she received a message from Mr. Gibbs that AC was not feeling well and that she needed to go to the hospital. It was at this point that Mr. Gibbs alerted Ms. Ballard that there was something that happened the previous day, that he was drawing a bath for himself, had stepped outside to smoke a cigarette, and that AC had gotten into the bathtub and fell into the bathtub. So Mr. Gibbs, along with AC, went to pick up Ms. Ballard from school, took her to the hospital. While she was there undergoing tests, she ended up becoming unconscious. They had to resuscitate her. Some not so good things were going on with this young 2-year-old. They eventually had to transport her to Rainbow Babies in the ICU unit, where they were trying to figure out what was wrong. The doctors there determined that she had suffered burns in the lower portion of her body, as well as potentially noted some kind of sexual abuse and trauma. Now, throughout this time, Mr. Gibbs had maintained his innocence when talking to doctors, police officers, and maintained that throughout these entire proceedings up to the trial where he testified on his own behalf. Mr. Gibbs was indicted and convicted of kidnapping as well as rape and felonious assault. Today we have presented 4 assignments of error. I would like to apologize for not mentioning this earlier. I would like to reserve 3 minutes for rebuttal.
All right, I'll let you know when you get close.
Thank you. So our first assignment deals with photographs that were permitted by the trial court. We argued that those photographs should not have been admitted, that they were substantially prejudicial, and that outweighed any probative value that the photographs may have had. Our second assignment of error is that lab results that came back from the Lab Corporation of America were testimonial. No one testified to those, which violated Mr. Gibbs' right to confrontation under the 6th Amendment. And we also have our third and fourth assignments of error, our sufficiency claims as well as manifest weight arguments. So in regards to our first assignment of error, the photos had significant prejudicial value, specifically Exhibits 16, 20, and 21. Exhibit 16 showed AC in a medically induced coma. She had tubes coming out of her body, she had wires everywhere. It showed a relatively disturbing image of a 2-year-old girl. There was no probative value because that didn't show any of the injuries that the state has alleged in regards to the rape, specifically that there was damage to her vaginal area as well as to her rectal area.
What about in regard to the felonious assault?
To the felonious assault, there are, if you look at the image of it, you can see little parts of her legs, but this was the post-debridement, which basically is when they remove the skin because of the burns. So the burns are going to, the wounds to that are going to be likely look even worse than they appeared when she first got to the hospital.
Well, if you limit the felonious assault to the burns, but couldn't the state's theory of the case be more inclusive? Sepsis?
It was our understanding that the felonious assault was more regards to the burns aspect of it. And that's, while that may hold some probative value, these pictures were shown to evoke emotion in the jury. If you look at these pictures, I was looking at them, and you take a step back and say, wow, this is, it didn't hold any probative value as to the rape accusations, as to the injuries that were caused from that.
Yeah, as I recall, there was no objection at trial to any of the photographs?
There was objection prior to opening statements. The trial court discussed it with counsel.
Was there a motion in limine filed?
I believe that there was a motion in limine filed for this.
For the photographs?
For the photographs. They were noted by trial counsel. So, in any event, the prejudicial value is substantially outweighs, any probative value that can come from these pictures, and we argue that, that these photographs should not have been admitted based on that. We would also argue too that the cumulative presentation of these photographs was prejudicial to the defendant, to Mr. Gibbs. The repeated showing to the jury to put these prejudicial images in the jury's head was also against Rule 403. In regards to assignment of error number 2, the court is obviously aware of the United States Supreme Court's ruling in Crawford that testimonial statements from witnesses who do not testify at trial are inadmissible unless that party was unavailable to testify and there was a prior opportunity to cross-examine. The testimonial statements here are these lab results that were obtained by the hospital doing a rape evaluation kit from Lab Corporation of America, which had no affiliation, which was a third party who completed the testing results. There is United States Supreme Court precedent in Melendez-Diaz versus Massachusetts, where lab reports of forensic analysis was determined to be testimonial. The biggest part of this here is that the evidence that they're trying to get from these lab reports is for litigation purposes. It's not in the ordinary course of business. They were trying to determine whether this young infant was sexually assaulted. And there was no testimony given by anyone from Lab Corporation of America who, again, conducted these tests. The state did not note whether there was any, whether they couldn't be there or were unavailable for any reason. There was no issue with cross-examination because there was no opportunity for that. So we would argue that under Crawford, these lab results should have been inadmissible and violated Mr. Gibbs' Sixth Amendment rights to confront his witnesses.
Counsel, was there actually an objection as to the lab report?
There was an objection to the lab report, again, prior to the beginning of the trial, prior to opening statements.
Okay, and again, I'm just going by briefs. You understand I haven't
Yes.
been able to read the record, but it was my understanding that that was the defense saying, no, we're not going to stipulate to that when the state was looking for stipulations. That's different.
That's correct.
It's different than an objection.
That's correct.
Although I'm not sure the trial court.
Well, the trial court, the way that the trial court handled it from my reading was that they focused more on whether it was admissible evidence under 803.6. And we would argue as well that this does not fall under 803.6 because 803.6 is for business records that you keep in-house. These were records that were sourced from a third party that had nothing to do with the hospital. Therefore, the hospital can't claim that these are their own personal business records. And we can find that in a couple district courts, Royce v. Dayton in the 2nd District in 2011, as well as Babb v. Ford Motor Company in the 8th District, where information businesses receive from outside sources does not fall under 803.6. So we would argue as well that the trial court erred in that regard as well. I know that the state in its brief mentions that that the invited error doctrine should be used in this issue. First of all, we don't believe that's correct because the state was actually the ones to present the issues on opening statements. They said on opening statements that AC did have chlamydia, sexually transmitted disease, in her rectum, insinuating that there was some kind of sexually disease transmitted to this 2-year-old girl, and it's not something that you're typically going to find in a 2-year-old's rectum. During cross-examination of the state's first witness, which was Mrs. Bowler, trial defense counsel found an opportunity to cross-examine in preparation for, potential evidence that was going to be coming from the state, from its doctors and nurses, to cross-examine Ms. Bowler. She had tested negative for chlamydia and admitted that she had been having unprotected sex with Mr. Gibbs prior to AC's admission into the hospital, and during and after.
Can I ask you, counsel?
Yes.
Am I correct that Mr. Gibbs testified on his own behalf here?
Yes, he did, Your Honor.
And did he also either testify or include some of his medical records?
He did include some of his medical records, but that was nothing regarding whether he had any sexually transmitted diseases, including chlamydia, was discussed.
So the not having it or a transmissible disease, that was with the child's mother? Yes, yes. And that seemed to, I don't necessarily think that was excuse me, I don't think that was necessarily an argument that that defense counsel, wanted to go down that route, but because the state presented that during opening statements, they wanted to take every chance they could, to rebut the notion that, she received chlamydia.
Counsel, you are 2 minutes and 50 seconds
Okay.
left. Do you want to reserve that time?
Yes, I would, Your Honor.
All right, we'll have 2 minutes and 50 seconds for rebuttal then. Say we'll have 15 minutes here.
Good morning, judges. Brian Murphy, Assistant Prosecuting Attorney, Lorain County Prosecutor's Office. First, regarding the 2 assignments of error that are really pre-trial evidentiary issues. Assignment of error 1 regarding the photographs is presented to this court as a error regarding a motion in limine. This court generally does not review a trial court's decisions regarding motions in limine without the proper objections on the record during trial at the proper time.
has our prior rulings on that been modified by the changes in the rules of evidence regarding motions in limine?
I don't know how to answer that at this point.
Okay, let's put it this way. They changed the rule and they don't have to object anymore. Would that change your position on this?
The rule, if the rule was changed, that they don't have to object anymore.
Just one time. Are you saying they never objected?
Well, first of all, with regard to the motion in limine, Judge, I don't know, and the record's not clear what photographs were marked with these sticky note post-it notes. So the record's unclear.
Okay, that's a different issue.
Correct. You're absolutely correct. From the state's perspective, the specific photographs that were objected to are the exhibits numbered 16, 20, and 21. As Mr. Gibbs pointed out, the state does not contest that. What the state contests is if you go back through that record and say, well, which photographs are relevant to the court's decision regarding the motion in limine, you can't tell. You're not going to be able to tell from the record, I don't believe, specifically which photographs they are. The photographs are described, they're described very much like the exhibits 16, 20, and 21, but there's still no definitive, explicit denotation in the record which photographs specifically Mr. Gibbs was objecting to, or were, I should say, were relevant to the motion in limine. So the specific photographs that were objected to, 16, 20, and 21, regarding the danger of unfair prejudice substantially outweighing any probative value. The photograph that shows AC in a coma, tubes, and other hospital mechanisms goes to show the harm that she sustained as a result of these traumatic events. It does show ultimately what occurred as a result of what she went through. Obviously, they are not very fun to look at, but neither are autopsy photos, which are permissible in prosecutions. Number 20 showed her stomach post-surgery, again showing and demonstrating what happened to her medically. That photograph showed just, again, that it corroborated that something had to be done inside and what was pulled from the inside. The obstructions, it looks like they're described as small stones or rocks, I think, in the testimony. And then finally, her legs post-debridement, actually showing debridement, showing the extent of the burn injuries on her legs. The state would also note that 403B is not relevant here. There's a difference between evidence being cumulative and repetitive and being repeatedly shown. The 403B argument really only pertains to Exhibit 16, which was shown to multiple witnesses. That doesn't mean that photographs were repetitive. It was repeatedly shown, but Mr. Gibbs can't demonstrate any prejudice because once it was presented to the jury and was going to come into evidence, it didn't matter whether one witness testified to it or multiple witnesses did. It was going before the jury, and you can't establish prejudice. Mr. Gibbs can't establish prejudice there. With regard to the second assignment of error, the chlamydia lab report, it's important to take into context, as you pointed out, Judge Callahan, the procedural context. This was offered when the court and the parties were trying to establish what evidence was being stipulated to, presumably as both with regard to authentication and admissibility. And defense said, this one specific document I'm not stipulating to. And this is where I think that it kind of devolved at the trial court. They should have just moved on. The trial court judge should not have asked the state, without at least declaring on sua sponte, raising or presenting the court's motion in limine, I guess, if it could even do that, but they should have just moved on. It was unnecessary. It was a premature ruling.
Did the trial court actually ask the state to make an
Yes.
argument at that point?
Yes. In the record, the trial court asked the state to make an argument. And I don't know why. If it's not being stipulated to, the state then has the obligation, the burden, to authenticate the document and present witnesses if that was necessary. The Mr. Gibbs argument revolved around hearsay and the business records exception, and there was a brief passing reference to the Sixth Amendment Confrontation Clause. I mean, it wasn't even a full sentence. I can't even believe that Mr. Gibbs and his counsel could elucidate an argument in less than a sentence regarding, or in one sentence, or actually less than a sentence, regarding Sixth Amendment and the Confrontation Clause. That just doesn't make sense. If the court is going to consider this, it's nothing more than a motion in limine. And with regard to the motion in limine, I'd point out that if an objection is not required at the appropriate time in trial, that becomes irrelevant because Mr. Gibbs' trial counsel stipulated to the admission of this document. And actually I write on page 16 of my brief as I reviewed for the argument that plain error is the only way that Mr. Gibbs could bring this argument before the court. Upon further thought, I don't even believe that plain error is relevant because he stipulated to the admission of the documents.
And didn't say with the exception of that report.
Correct. Never did. And with regard to the chlamydia issue, the first time that it comes up, as during an evidentiary portion of the trial, was on transcript 176 and 182 with AC's mother testifying. It then came up multiple times more. The state never brought up the issue of chlamydia.
How about an opening?
Opening's not evidence, Judge.
But the jury has ears.
Sure.
And I know, we all know they're told it's not evidence, but it'd still be pretty damaging an opening, yes. Could be.
Could be. The opening statement's not evidence. The evidence that came out, first time it came out during evidence, was defense asking about it. Asking the mother, asking medical personnel. The state's only reference was with Nurse Hackett on transcript 357, 358. I searched for the word. It came up numerous times with defense counsel. And in fact, the first reference to the report itself was at 305 to 308 of the transcript, the segment of the testimony of Dr. Storm Morgan.
So I'm assuming there was no sidebar or objection to
Correct.
the discussion of it in opening.
Correct, Judge. So without the objection and combined with the stipulation, again, the assignment of error fails. With regard to the sufficiency of the evidence, judges, the identity, I believe, seems to be the first issue raised in assignment of error number 3, and that was Mr. Gibbs, the person responsible for perpetrating sexual abuse that led to the serious physical harm. Judge, I think the record's pretty clear that the state's version of events, theory of the case, was that the serious physical harm was predicated upon the burns. I think that that's relatively clear from the record, and not from what occurred internally to AC. Appellate courts have, there's 6 cases cited in the state's brief that defendants are criminally liable for injuries and even deaths that occurred when Defendants were the sole caregivers, caretakers, custodians. At the time the incident likely happened or definitively happened. There's even a case of the 4th District, Meadows, from 2001. Very similar circumstances of peritonitis, which is the condition that AC suffered from in this case. That was the defendant's stepdaughter in that case, a 3-year-old girl. She was alone with the victim. He was alone with the victim, and the defendant, or victim in that matter, ended up dying. Murder conviction was upheld. In this case, based on medical providers' testimony, law enforcement's testimony, and even Mr. Gibbs' own testimony, this 2-year-old was in his sole care and custody during the relevant time period. There's an allegation of, well, she was in the custody of other family members some 4 days prior to September 17th, about September 13th. And what one of the medical providers, I believe it was Dr. Storm Morgan, said was, if these injuries were caused on or about September 13th, there's no way that this girl would have made it to September 19th, 20th, and the 21st, when I believe the surgery occurred. With regard to the sexual conduct, sexual activity, Nurse Hackett testified to red marks that she believed were tears. They were linear in nature. She had to use a special medical instrument to see them. There was redness on the inner part of AC's labia minora, the inner part, the inner lips of her vagina. This is a 2-year-old girl. Those injuries shouldn't have been there. Neither should the blood that Dr. Lafay saw or the rectal tears that Dr. Storm Morgan testified to. All of that was non-accidental. There was no medical, the testimony showed no medical reason for it, and there was no, it wasn't something that AC could have caused. Somebody had to have caused those injuries.
You have 2 minutes left.
Thank you, Judge. And the way that they would have been caused was from penetration, is what the medical providers testified to. There's a last paragraph in that sufficiency argument about knowingly causing serious physical harm. It was unclear to me whether it was really identity. I think serious physical harm is pretty clear here in 2nd-degree burns, or whether it was a mental state. If it was a mental state, the water was obviously hot. Dr. Storm Morgan testified someone dumped the child. The evidence suggested someone dumped the child because she couldn't get into the bathtub on her own, her mother said, without injuries above her waist. She didn't fall in, and therefore someone either put her into really hot water knowing it was hot, or knew it was hot without testing it to see just how hot it really was, which would support the conviction. The element of serious physical harm. But it goes to identity, sole care and custody, again goes to that issue. With regard to the manifest way, really the question becomes who hurt AC? These traumatic events resulted in tears and redness to the inner part of her vagina, rectal tearing, injuries around her anus, blood in her vaginal area, and 2nd-degree burns. Again, non-accidental. She didn't cause them. They were recently inflicted from sexual assault, blunt force trauma, according to medical personnel, and being deliberately dumped in the water. I'll leave you with Mr. Gibbs' own testimony, which was, I was the only person there. I was the only person there. And yes, I admitted that. Yeah, maybe that made me look bad. I don't care. I was the only person there on 478. The jury found the state's version credible, so we ask you to affirm the convictions. Thank you, Judge.
Thank you, counsel. And counsel, you'll have 2 minutes and 50 seconds left for rebuttal.
Your Honor, Your Honors, in regards to assignments 3 and 4, assignments of errors 3 and 4, the state seems to allude in its brief that it doesn't have any direct evidence that Mr. Gibbs was a person who sexually assaulted AC. Their version of the facts seems to rely upon whether based on the injury and the timing of this tragic event. The biggest issue is, one, the timing. Now, there was times where Mr. Gibbs was the sole caretaker of AC, but there were also multiple instances where Ms. Bauer was home when she wasn't at school or at work. So there wasn't this, from the 13th to the 18th where he was the only adult in the room or in the area with AC. And I know that Dr. Smorkin testified that if this happened on the 13th, that she wouldn't have made it to the time that she was. Well, what if that happened on the 14th? What about the 15th? What about the 16th? None of those times did the state allege during its presentation of evidence that Mr. Gibbs was the sole caretaker of AC. The only time that they can say is the 13th of September. There's also an issue as to whether, as to who caused the injury. So they can't exactly say when it happened. So because they can't put Mr. Gibbs in a time frame, there's a large spectrum of time that they can't necessarily account for. The AC was in the custody of different people throughout this time period. And it would be wrong to infer that, that AC was in the sole custody throughout this entire period. And there are some testimony from the doctors talking about how there might not have even been sexual activity or conduct. For example, Dr. LaFay testified that there was no apparent genital trauma at the initial evaluation at Mercy Hospital. Dr. Smorkin testified that the child had externally normal female genitalia. These are, evidence to show that there wasn't any kind of sexual assault.
Counsel, with that, you have used up your time.
Thank you, Your Honor.
I want to thank you both for being present today and arguing. The court will take the matter under advisement, issue its decision in due course. Of course, the clerk of courts will mail each of you a copy of the court's decision on the day it's released, and the opinions are also posted on the Supreme Court of Ohio's website. But again, we want to thank you for the arguments presented this morning.
Thank you, Your Honor.